show, and I thought, I haven't given any case updates in a while. I do keep my clients updated, but kind of want to let you know because a lot of you supported me through law school and in getting my firm set up, and so I think I'm going to try and make this a regular thing, but I can't promise it because, by golly, when I'm on the road so much, it's hard to be consistent with anything because you never know who your next client's going to be, where he or she's going to be, and all that kind of stuff. But I've got many cases I'm working on right now. I'll go over kind of a few of them, a few of my successes that I've gotten. This week was a pretty productive and frustrating week in many different ways. So I got the ATF to release 2 firearms on pistol brace issues because they are members of Gun Owners of America, and therefore they're protected by the injunction, and we're trying to claim that they have these pistol braces. The problem that I'm finding right now, and so if you've got a pistol brace and you're getting a letter from the ATF, or maybe you're being threatened to be arrested, then look me up, give me a call. By the way, stop whining about the fact that I'm filming this in portrait mode because I'm in my car. Okay, so suck it up when I do these lives in my car. That's just the way I do it. All right, that aside. So, first of all, the ATF isn't even following their own rule. The ATF seems to think, these ATF agents seem to think that the ATF rule bans all pistol braces. The ATF also seems to think that if you did not, if the pistol brace that you bought was not vetted or approved or submitted to the ATF or by the ATF, then that automatically makes it illegal. Okay, I've got a video on this channel. If you want to know really how complex, broad, unconstitutional, and confusing the pistol brace rule is, I've got 2 videos up. One that's an in-depth description and discussion of the rule, and another one that kind of summarizes the rule. Okay, but first and foremost, if you've got ATF agents thinking that pistol braces are now illegal on AR-15s, then is it any wonder that regular law enforcement and the public seem to think that they have to give up their pistol braces? That's not the case. All right, so I got 2 pistol brace firearms returned. One of they tried to put conditions on it. Hey, look, we'll give these guns back if you agree to take off the pistol brace. And I said, no, we'll get the guns back with the pistol brace because they haven't broken any laws. Your rule, as applied to my clients, does not exist. A judge has said so. Now, if you would like me to file contempt paperwork with the court because you are refusing to obey the injunction, I'm willing to do that. You just let me know how you want to move forward with this. So there's that. We got a new client this week I'm going to see Monday. The client was raided by the DOJ. Why? Because he went to the Capitol on January 6th. Did not enter the Capitol, did not go into the building, but was present and allegedly, according to the indictment, had a firearm with him at the Capitol. How do they know that? They saw a bulge. Now they've got some other so-called evidence, circumstantial evidence, that they say kind of proves that, well, that bulge we saw was a gun. But that's not going to fly either. So now my representation in this case is very limited because it's only while he's in Texas. He is going to be extradited to DC, and we'll have to get an attorney there, of course, because they don't want to try and hear where he'll get a fair trial. They've got to file, they've got to, do it in D.C. where they vote 80% against Trump and against Republicans, and so the jury pool is a surefire way to get yet another conviction. And part of this, my personal opinion, it's not a legal opinion, it's a personal opinion. It seems to me that the DOJ essentially got the two people he went there with to flip on him, and because they were able to go to, and none of these people went into the Capitol. And by the way, no one was hurt. He didn't attack anybody. He's being charged because he existed in a predetermined area that the government has decided you have no rights. Okay, no right to the First Amendment, no right to the Second Amendment. That's it. He didn't do anything criminal other than existing and not exercising his rights in the unconstitutional way that the government thinks he should have been exercising his rights. So anyway, Monday I'll be visiting with him at the facility where he's being held. I just want to make sure that he's being treated right, and representing his wife as well, to make sure that she's been treated right, that they both know what their rights are, etc., etc. Had several hearings this week, all over the state. I'm not going to say exactly where my clients are because I don't want to identify them in any way, even though they've given me permission to talk about their cases. I want to stay generic because I don't even want to put them or me in that situation where there's an allegation. So I just speak broadly. So I've got cases where, the city has charged a client with ordinance violations in which they decided to do a raid, mind you, a warrantless search of a business. They went and got a warrant after the fact. Well, the client did a great job, pro se, at the municipal level, got the evidence suppressed because it was warrantless, so anything they collected can't be used, therefore they have no case. Well, guess what the city did? Because we live in a state here in Texas where it's not about punishing, or that they're going to get punishment for any actual crime or criminal activity. We live in a state where the punishment is just putting you through the process. If you don't toe the line, if you don't do as you're told, if you dare to stand up, if you dare to evoke your constitutionally protected rights, then what they're going to do is they're going to just put you through a process, knowing they're going to lose. But the goal is not to win, because to them, well, I guess the goal is to win. The goal is to win. Let's just say the goal is not to get a judgment in their favor. To them, a win is you having to fork out money, fork out time, fork out energy, effort, and forego money in the form of, working instead of having to fight these things. And so, it's that whole you can beat the rat, but you can't beat the ride type mentality. So he wins at municipal court. Do you think they give up? A judge has already said that, look, you didn't have a warrant. Okay, you should have gotten the warrant before you went in there. There was no existential reason, or, that exigent reason, excuse me. I've been listening to too much climate change talk. There's no exigent reason that you had to go into the house without a warrant. So we're throwing out the evidence. And instead of just saying, you know what, we screwed up, guys, don't do this again. No. What the city's doing is now they have appealed to the county. And now this is going to become a county trial. And it's called a trial de novo when you appeal a municipal. Generally, many municipalities, the appeal is really what's called a trial de novo. You have to put up an appeal bond, which is generally the cost of whatever the ticket would have been, and that's put in sort of an escrow or a trust account while you appeal to the county in a court of record. So now this guy, he's brought me on. We're going to do the exact same thing, and we're going to win that. Then we're going to do a civil suit with malicious prosecution, among other things. Got another client where went down to that, had a hearing for him, and this was essentially they're calling it criminal conduct, alleging that a windshield was busted out. You know, when somebody tries to run you over, you're supposed to just take it. Okay? You're not allowed to defend yourself. You're definitely not allowed to punch a window that is, inches from your face or inches from your body. So we're getting that taken care of. I've got another, we got last week or week before, got some organized criminal activity charges, felony charges dismissed. Client was also charged with a misdemeanor of, like I said, swatting himself. Got the felony charges dismissed. Had a hearing this week for the misdemeanor charges that I requested because they hadn't even arraigned him on anything because they are showing that he never got arrested for it. Well, he did. He's bonded out. So I went down there for that. I filed a motion to dismiss for the exact same reasons as the felonies. There's no crime. There's no criminal activity. It's a case based on open carry. The city or the police department seems to think that if you carry a firearm legally, they can pick and choose. Well, the only reason he's open carrying is because he wants someone to call 911, and so therefore you're inducing an emergency response call. And what ended up happening was someone called the police and said that there's a guy with a gun holstered. Actually, I don't know what the 911 call specifically says yet. I got the discovery yesterday, but I haven't gone through it all because I've been on the road all week. And I'm on the road again right now, going to a radio show. So if you want to go on Facebook, Aaron's Gun Shop, his Facebook page, I'll be live there in about 15 minutes. Anyway, so they refused to throw out the misdemeanor because after we got the felony charges thrown out, one of the so-called alleged co-conspirators, because you're allowed to, the turn review driver says you're allowed to film the police. And the police seem to think, well, that just says that, only Philip Turner can film the police. But if Philip Turner gets 3 of his friends to also film the police, well, that's a conspiracy to commit organized criminal activity, filming the police. And if you park somewhere where you can see the police, that's called tactical parking. Even though you're parked in a marked parking space in a public place, the fact that you parked there so that you could see police is evidence of, that you want to kill them, I guess. That's what they're trying to allege. So the prosecutor in that case is refusing to dismiss the misdemeanor because she wants to figure out what she's going to do with the felonies. Well, I'm sorry. My client's charged with a misdemeanor. And there are no felonies. If you want to reindict all you want. I'm not going to sit around and let my client have a charge hanging over his head because you're trying to protect the police from getting their asses handed to them in a lawsuit. So what I did was, instead of what I normally do, and what most attorneys do, is, okay, well, we'll just reset it. Nope. I demanded a pretrial, or I set a pretrial hearing for our motion to suppress the arrest. motion to suppress the information, and then asked for a trial. And we're going to trial. We're ready for trial. I mean, it's not hard to be ready for, to defend a client for something that doesn't exist. Hell, I might not even have to present witnesses. As soon as the prosecution is done with their case in chief, I just do a motion for a directed verdict because they didn't present any criminal activity. There's no way they can present any criminal activity. So I think what we're learning here is the only organized criminal activity happening that involves my client is by the organized criminal thugs of this particular police department that seems to think that it can use the justice system as a retributionary and disciplinary system. It's not what it's for. So, all right. Anyway, so there's that case. That's going to be on September 11th. Had another client, went up to his hearing, filed a couple of motions. Got the discovery for that. We've got trial here in a couple weeks. It's another First Amendment case. The officer demanded that my client, as he's walking up to the scene of a hit and run, so it's just an accident. That's all it is, just an accident. Nobody's getting ticketed. Nobody's under suspicion of a crime, at least at the scene. My client starts walking up, and as he's crossing the road, the police officer tells him to stop. He stops in the middle of the road, on the crosswalk, of course. Tells him, you need to go away, go that way. He's like, well, no, I'm going to go over here. I'm filming. I have a right to film. I have a right to move. I'm not interfering. They get into a discussion. He starts to move again. She tells him to stop again. He's trying to get out of the road. She tells him to stop right in the middle of the road. And finally, when he decides to turn around and go to the other side, they decide to arrest him for obstructing a roadway. Well, sorry, that doesn't meet the elements of that crime either. So there's another lawsuit once I get these criminal charges of a Class C misdemeanor of standing in a roadway. By the way, there were no cars. This was in the evening. No cars were coming. Nobody was obstructed. Nobody was prevented from moving. Nobody had to drive around him. Nobody had to walk around him. It is not a crime to stop in the middle of a road. Under this logic, just standing on a sidewalk, okay, just standing there, because the same code not only deals with roads, but it also deals with sidewalks. It says sidewalks and roadways and, a few other things like that. So by this prosecutor and city's thinking, if you're just standing on a sidewalk, you're obstructing. When we all know, and the legal community knows, and the courts know, and the case law knows, that if you're going to charge someone with obstructing, they have to actually obstruct something. If you're standing on a sidewalk and people can't, and you're blocking them for no reason, you don't have a permit, and you're just preventing them from being able to utilize the public sidewalk or the public road for no legitimate reason. Let's say you broke down on a highway. That's not obstructing, okay? It's not your fault that your vehicle broke down. I mean, it might be, but it's not criminal. It's not intent. And so their thinking is, if you're just standing on a sidewalk, you're obstructing. They can arrest you. They can throw you in jail. By the way, for 5 days. Yeah, we're fighting that as well. All right, guys, I am, if you want to go on Facebook to Aaron's Gun Shop, I am pulling into the radio show right now. I will be there until about noon. And we'll see you at Aaron's Gun Shop High Cap Adventures radio show in about 5 minutes. You guys take care. I'm keeping busy. Kind of wish I wasn't keeping busy, but bad cops make my job necessary. Take care. Be safe. Be free.